90.3 WHPC now presents Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now, learn about the law and how to protect yourself against the loss of your liberty or property, and learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau, a past dean of the Nassau Academy of Law, and frequently lectures to lawyers on ethics and avoiding problems with clients, and to the public on how to choose and use lawyers. This is Law You Should Know on the voice of Nassau Community College, 90.3 WHPC.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we'll be talking to attorney Barry Seidel, based in Queens, and a frequent lecturer and author about practicing law in a pandemic, especially if you are a small or solo law firm. Barry, welcome back to Law You Should Know.
Thank you. It's nice to speak with you again, Ken.
You always have good tips for people on managing and building their practices. So I would like you to give our listeners, even if they're general public, about things they can and should do to keep their practices going and to try to grow their practices during the pandemic.
Well, I think the main thing for people to keep in mind is perspective. You have to step back and see reality as it is and adjust accordingly. So for lawyers in practice, it's a good idea to kind of step back and look at what was my practice, how did it function, what do I want to do going forward, and who are my clients, and what changes do I have to make during the pandemic to make sure that I'm continuing to function, and that if business comes back and when business comes back, that we are addressing it and dealing with it accordingly.
So they need a plan for now, and they need a plan for post-COVID, or as we're moving through another phase of COVID.
Yes, I've also found that one of the, I don't want to call it a benefit, but one of the things that came to light for me, and I think it's true for a lot of people, and if you don't see it this way, I'd urge you to take a look at it this way, is that the time when business slowed down or stopped was and still is a good time to assess what we've been doing and how it's been working. You know, in the day-to-day work that we all do and dealing with clients and courts and financial issues and personal matters, we rarely have had the opportunity to step back and look at, am I in a field that I like? Do I have a client mix and a case mix that I like? Are my numbers what I want to be? Do I even know what my numbers and my finances and my trends are? The entire pandemic has been a good time to look at those things, but even if somebody has not been looking, now is as good a time as any. And I think while you could say in a perfect world, one should have been doing that all along, the reality is many of us can't or don't. And now we can, and we can make informed decisions and choices going forward.
And someone can, in addition to seeing where their revenue comes from and what skills and talents, they can reassess their needs and try to evolve their practice for the needs of their clients or potential clients, and also going forward.
Yes, for many of us, the practice areas that we've been doing are directly affected by the pandemic. And so if we sit back and just wait for it to get better, now listen, there are some areas where it might get better, but there's plenty where it isn't, or it's going to be changed, or there may be areas of practice that you were a little interested in and wanted to learn that are going to come into favor or get busy. Now would be the time to be looking at all of those things. And when I said before about perspective, that's kind of what I mean. It's sort of like step back and take the long view. If this is what I was doing and it was okay but not great, or if it was great but it's not there, have the perspective to step back and see reality for what it is and try to grow into a plan of your own creation instead of just being reactive.
So is it a good time to reassess your situation, see what work you like, what work has dried up, and think about what areas, and look at it in terms of how you can help people, how you can help other lawyers, relatives, friends, what are their needs, and find something that among their needs that you might enjoy doing. Perhaps it's renegotiating business agreements, or leases, or helping someone to transition to a new phase of business, or to prepare a will. People are concerned about wills and estates now.
We all, to one extent or another, have had to adjust. And, for me, when the pandemic happened, I was doing two main areas of practice. More than half of my income and more than half of my time was spent on a per diem court coverage service that I've discussed with you previously. It's sort of an adjunct to law practice, kind of a service business for lawyers. It was the main thing I was doing, or at least certainly more than half at the time of the pandemic. The other thing that I was doing, which was less than half my practice, but something that I liked, was a private practice area involving probate and estate administration, which was basically all kinds of cases and all kinds of things that happen after someone dies, whether there's a will or not, friendly, unfriendly, lots of cases with that. It was something that I was doing. It was a meaningful part of my practice, but not the majority. When the pandemic hit and court essentially closed, the per diem business not only stopped temporarily because court was closed and there was no need for lawyers to send other lawyers to court on their behalf. My belief is it's probably closed for the per diem lawyers permanently, because during the pandemic, a lot of the things that were being done remotely as a stopgap measure, the court has made it pretty clear they're going to adopt most of these as permanent. The new way, the new thing in the aftermath of COVID is going to be many, many less appearances that would lend themselves to per diem. I saw this early on in the pandemic and realized that something I had been relying on was no longer there. I'm not going to say I cried over it because I didn't. It was upsetting at first, but I quickly got to perspective mode and said, well, okay, I can keep my eye on that for whatever per diem business may rise from the ashes, if any. It's now September. Since March, there haven't been any, other than a couple of virtual appearances. But for all intents and purposes, finished. However, I had something that was kind of the minority of my practice and my time, which was probate and estate. And it sure looked like, with the number of people that died in New York and all over, that it would be busy. But one would make a mistake if you assume that it would be totally busy right away and just going to switch gears. Much more involved than that.
But I think people are also interested in the planning. There's a greater concern about having trust or having a will or revising wills.
Many people in their private lives, and this affects what they hire lawyers to do or what they consult with lawyers about, have with the onset of COVID, really looked at a lot of these issues and are thinking about wills. If a simple will is appropriate, I do those. They're appropriate for many people. Or doing more involved types of estate planning or Medicaid planning and dealing with all of these issues that many people put off. They had time to deal with them. Some are dealing with them in the pandemic. But more than that, people are thinking about these issues in a more action-oriented way. As an attorney, I'm conscious of that. And I want to be able to service people that want to do that. And when I said you have to adjust, it's not just that there's new business. There are new ways of doing business because not everybody is willing to or able to come to an office. There were new rules put in. They're temporary, that some of them may become permanent, about remote signing and remote notarization and remote will executions and powers of attorney. Lots of issues to stay up on and lots of new things to do as clients are more interested in these things.
And is one of those an educational component? Should lawyers, sole practitioners, small law firms put some focus on educating people to show off their expertise, to show off how they can be of help to individuals or families or a small or large business who may be going through a transition?
Different lawyers approach that issue in different ways. I am on the extreme end of putting useful information out there for clients. I never worry for 1 second that somebody is going to take good information that I put out there and try to do it themselves, and I'll quote unquote lose a client over it. If something is something someone could do themselves, they should do it themselves. If somebody learns enough from what I've put out there to say, gee, now I understand what lawyers do and why lawyers get paid and what's involved here, and it's just something that's not something that a person's going to do without professional help.
Like taxes, at some point you may think it's too complicated. But also by doing that, are you setting yourself apart from many lawyers by giving valuable information, sharing that with the public, and then offering your services if they want to take the next step?
I think so. When you consider that the way that most people research a question or find a lawyer or find out about things is they go on the internet and Google it or use some other search engine and ask about that. If you're talking about these things in any kind of a public way, whether it's on a blog, whether it's on your own social media, when I'm on LinkedIn or Facebook or Twitter, which I'm on all of those, some of it for personal, but most of it for professional reasons. I will post information that's useful about current topics. I've been doing it on the per diem side for lawyers. I've been posting current information about the court system. Lawyers seem to appreciate it. They seem to thank me for it. If that business comes back, I got a feeling they're going to remember it and contact me. But even on the probate and estate side, I'll put out information about why people should have wills, what to do if somebody dies, what to do if somebody calls you, a family member with a situation. I put the information out there because you never know who's going to see it, and you're the one that's talking about it, and your contact information is there. That's how you grow a business.
And it's good to make sure the information is valuable and understandable. You're not writing War and Peace.
Well, I mean, if you're a lawyer and you're writing like a lawyer, you're in places where you want your clients to understand it and contact you and like you and want to deal with you, write like a regular person. Tell the story. Put it.
You want the Daily News, not the Wall Street Journal.
100%. Although I find the Wall Street Journal pretty readable, but
to you.
Yes, but you put the information out there. Use examples that are concrete. You change the names, but I'm not adverse to putting out an example. So and so died. They had a house. It was worth $500,000. They had 3 children, Billy, Bobby, and Timmy. Here are some of the issues. If that's pertinent to what I'm talking about, people can relate to those types of real stories.
And it also establishes you as experienced and caring about exactly that type of situation they may be confronting.
Yes, there's an old adage in writing, show, don't tell. And that applies in marketing and advertising and promoting oneself. I could say all day long, I'm experienced at that. I know how to do this. My fees are good for that. That might work with some people. Some people might respond to that, but people are much more likely to respond if you're not saying that, but you're just talking and acting and being like you are that. When I'm talking about things, and I'm not saying I'm experienced with that, the way I talk about it is saying to people, I'm experienced with that. I've done that before. I know how to talk about it. And also, I know how to talk to real people like another person, not somebody that they can't relate to.
And you're gonna find some price or project they can afford. You're not going to let them worry that it's going to tally to thousands of dollars.
Well, I'm realistic and upfront about what the fees are. So not everybody is going to be the right client for me, and I'm not going to be the right lawyer for every person. My fees are reasonable and fair for what I do. I spend a lot of time, probably proportionally more time than most lawyers, assessing what the case is about before I'll propose a fee or a fee arrangement. That's to be fair to both sides. It's to be fair to the client and to be fair to myself. Sometimes clients are surprised when I say I want to be fair to myself, but if someone calls me up, what do you charge to do X? I never answer that question. It's not because I'm evasive. It's because I need to clearly define what X is so I can make a good decision whether I can do it and how much the fee should be.
So you're gonna spend a few minutes getting a better description of who they are and what their goal is, and then trying to give them a ballpark or a range of possibilities.
Yes, if I can flat fee something and say this is what it will cost. If I've got a basic probate situation, we're trying to get someone appointed after someone died. Some of those are very simple, some of those are a little more involved. But if I can ask the questions based on my experience that I know these are the things and these are the papers we have to file, this is who we have to contact, this is what we have to do. If I can get a good sense of what it is, I can flat fee something like that. I like to use this analogy, Ken. When I look at a new probate or estate or any kind of case that's being brought to me, I'm like a guy in a body shop who's coming out to assess the wreck and give you an estimate. I sometimes think I'd like to have a Zoom meeting where I walk in with a little shirt with a logo on it and a clipboard, and I'd come out and the person will say, well, here's my wreck. And then I'll ask questions. Okay, I see here we have this and we have this, and then we have to, so there's going to be labor to do this and this. Then I would say to the person, I've done this. And I'll say, now we have certain parts. And they'll say, what do you mean parts? Well, if I find out when we're talking that the filing fee for this is going to be whatever, $625, I have to build that into my estimate. Then we have another thing. Sometimes you don't know some things about the situation until you get into it a little bit. So that's the equivalent of when you're doing an estimate at a body shop saying, well, there may be damage to the engine or the undercarriage, but I won't know that until I go in there and take a look. Therefore, I can't give an estimate on that yet. And I think when you explain it that way, most people understand that. I'm just being fair.
And Barry, we're going to come down to your real-world estimates in a minute. I just want to remind our listeners, you're listening to Law You Should Know on 90.3 FM, WHPC. Also, this will be a podcast, and along with other podcasts about the law that you can find after the program or tell someone else about it at nccradio.org. We're talking to Barry Seidel, who's, because of the pandemic, is focusing his practice on what was half of his prior practice, wills and estate issues. Now, you used a very good analogy where there's a wreck and you're trying to help people repair the car and get it running, and there might be different ways of accomplishing that, and you go over that with them. What if it's preventive? They just want the will. So someone wants to polish the car. So you're going to have a chance to describe to them different types of polish and what it will do and what it won't do.
Yes, I'd give people the options based on what their situation is. But of course, everybody's situation is a little different. So I don't do this to be evasive or tricky about it. I can't make a will or price a will if I don't know, well, who's involved? Are there spouses, children? Is there an elderly person involved? Is there a disabled child involved? Are there minors? Is it a friendly family situation or not? You know, you have to be very careful. If you're doing a will where you're cutting someone out who might be able to contest, I would be more careful than the extreme care that I always take in how the will gets signed and how it gets done and what the paper trail looks like. If I know that I've got someone lurking in the future who might be priming up for a will contest.
And so you want to build a bulletproof will.
Yes, I want to do it appropriately for what the circumstance is, and I know what the circumstance is because I find out before I kind of get into it and quote somebody a fee with as yet unknown work.
So this informal consultation is going to be a few minutes these days, I guess, over the phone or Zoom, and you're not going to charge them for that ballpark estimate consultation?
My general approach is if I'm having an initial conversation to determine whether I want to be involved, I do that for free. And now that does not mean it is unlimited or repeated. In my mind, a 15 minutes or a half hour would be enough for me to find out what it is so that I can make a proposal on it. I'll do that. If there's something where further research is going to be required or further documents have to be reviewed, or if somebody in an initial meeting says, can you review these documents? Well, that's not included in a free telephone call. So I'm extending myself to somebody. I'm giving a free consultation and I'm talking about what the issue is. Part of that is to see what the proper fees are. I don't go back and charge the person for that part of it where I figured out if I wanted to be involved.
And you feel that through that and with that, you're getting them comfortable talking to you. They don't have to worry about the fee for that 15 minutes. And you're going to see if you can be of help to them and they are a good client for you.
Yes, and it's also another example of show, don't tell, because hopefully, and I'm quite assuredly, if I'm speaking to someone about a topic of interest to them, a personal family matter with some legal issues, just from the questions that I ask and the way that I approach it and the issues that I identify that they might not have thought of, or things I tell them about the court process and the procedures that would be needed, I don't have to tell them that I know how to do it. They know from talking to me. That's another reason why I like doing a free initial consultation on the phone. But I would say, but I would also add, I would not agree, and I didn't even before the pandemic. I don't agree to an open-ended come to my office and see me in person.
And certainly not for free. Now, do you have some closing line in that? You have that 15-minute exchange. You give them a quote. Do you do something to take the next step?
Well, usually there's going to be some kind of finishing off action or question. Many times people have to speak to other family members before they get back to me. Sometimes we might leave it where there's some additional item that they want to send me, and I'll send them my contact info, or I'll say I'm going to email it. but it's usually, we usually know by the end of it, somebody is contacting somebody and following up in some way, and how are we going to do that?
And you're trying to create a good impression, a good experience. It's more of a soft sell approach.
Yes, and also sometimes the sort of end of that conversation after I hear what it is sometimes I can quote a fee or a fee arrangement right at that point, where I might say to somebody, I can do this for a $3,000 flat fee, and the court filing fee is going to be $1,250, so that would be something that have to be paid in advance. But I also might say, this is something that does not lend itself to a flat fee, and if I was going to do an hourly, this is my hourly rate, this is what a retainer is, this is what it means. Let me know if you want to proceed with one of those, and I'll send you a retainer agreement.
Do you give them options of a flat fee versus a retainer, or retainer plus certain add-ons?
I will do that in certain situations where it's appropriate. Generally, in a straight-up probate situation, it's going to be one or the other. That's usually what a client would want. I have certain other types of cases that are kinship-type cases. These are cases involving distant relatives who are inheriting, and in those, I will give people options. I actually have 3 different ways I'll propose it. All of them are fair to me and to them, and I know that, so I'm comfortable doing that. And the 3 arrangements are a straight hourly with a retainer, a straight contingency where I'm getting a percentage, or what I call a hybrid, where the person is paying some money up front, paying something towards the expenses, but I will then reduce the contingency percentage, sort of like they're buying down.
Barry, we have to take a break. When we come back, I would like you to explain to the public listening and lawyers listening about other areas they should promote that you might be considering promoting, or that they should promote to themselves. I just want to remind our listeners that you're listening to Law You Should Know on 90.3 WHPC, the voice of Nassau Community College in Garden City, New York. This program and podcasts of many of our other law shows with information helpful to the public are available at nccradio.org. So Barry, you've taken us through a consultation. I think was great for the public and for lawyers out there. What do you think are other good services for lawyers, maybe not yourself, but for other lawyers out there to promote to the public? Real estate, looking at leases, contracts. What were especially timely services? I mean,
there are a few that are really obvious and out there, and I'll tell you what I think they are. And you have to know that this is not brain surgery where I'm the only person that thinks this. So other lawyers are going to go into these fields. And I would say to anybody, if you're going to go into a field that's a new field for you, or something that you did a little that you're going to do more, do it because you like it. Do it well. Learn how to do it well. Pay attention to your office flow and your workflow and how you do things. So with that said, obviously, bankruptcy on the personal level and on the business level is going to be extremely busy in the months to come. There's no way around that. The effects of COVID on the economy have been devastating. On the bankruptcy side of things, there's both sides of it. So there's creditors aspects and there's debtors aspects. Both are going to be extremely busy. So that's one. Housing court, for attorneys in general practice or attorneys in regular day-to-day practice, is also going to be, especially in the New York area, just a huge area. There's going to be a backlog of tens of thousands of cases. Most of the landlord work is in the hands of volume firms, but New York is so big and there's so many cases that there's plenty of new cases are going to come into the system. But there's also tens of thousands of unrepresented tenants. Not all of them need a lawyer. Some of them can do it pro se. Some of them can avail themselves of legal aid that is available on the civil side. But I think there's going to be a big demand for private retained lawyers on the tenant side of things.
They'll have a lot at stake and a lot of money involved for back rent and their future residency. We're running low on time, Barry. Tell us about your website where lawyers and the public can find out information about your services and about your most recent book.
Okay, I wrote a book. It came out last November. It was called Evolutions of a Law Practice: How I Went Directly into Solo Practice Right Out of Law School and Lived to Tell About It. It's a memoir. I have a website for it, www.evolutionsofalawpractice.com. It's available on Amazon. I'm getting some nice reviews. I'm happy I did it. It was something that I had thought about doing for a long time. So that's something that I feel quite proud of. I have a website for my probate work, which is www.queensprobate.com. There's lots of interesting articles on there, interesting, I think, about basic probate issues, kinship issues, what do administrators do, what happens if there's no will, who needs a will, what are the most important situations when wills are needed, etc.
Barry, I just want to mention, because you're the marketing guru as well as a very good practitioner, you mentioned your website, queensprobate.com. Is it important for lawyers to have a catchy website? Should they buy keywords for Google searches in a local community?
I mean, you're asking a question that could be a whole podcast or two or three.
Let's have the 1-minute version. We'll have you back for that.
The 1-minute version is that lawyers should be using this time to upgrade their websites to make them functional and attractive to clients, to have the communication be easy. Whether lawyers should advertise and use Google ads, they should if it's appropriate for what they do. But for many of us, bringing in somebody that really knows how to do it and how to evaluate the keywords and how to pay for them and how to market for them, there's a lot to it. Or spend the time researching it yourself. And I did a combination of both. When I initially tried it, I wasn't thrilled with the results. I got business from it, but I kind of knew I hadn't done it as well as I could have. I did some research. I upped my game. I brought in someone to help me with that. You make your business decisions. And that's the thing is, step back and you make your decisions. I have a mantra. I've probably told you this one before. The main thing with all these things is when you do things, things happen. If you just sit back and think, maybe I should, I'm thinking, I'm learning, at a certain point, you try things, you pay attention to the results, part of perspective also. You've
handled these things for lawyer clients and for the public. What are your closing words to them so they will refer a relative or, let's say, another attorney to you? And how do you keep in touch with them?
With lawyers who refer cases to me?
Well, even the public. You've done a will for someone. You've handled the probate. Do you ask them to spread the word? Do you ask them to put in a good review on Google?
I do. I have a form that people, if I know that I finished the matter and it had a nice result with good feelings, I give people a link that they can fill out a simple review on Google My Business. Goes a long way. People do look at those things when they're checking out a lawyer. And most people, if a lawyer is referred to them, even by word of mouth, they look the lawyer up. I know that. And if you're a lawyer and you don't know that, you should know that. People look. Sometimes
you also tell that satisfied client that you'll give their friends, relatives, neighbors a free 15-minute consultation as you did for them?
Yes, if that's an issue. But I think they kind of know that. I think that it comes across to people that I treated them special, but I like to think that they know I treat all my clients as individuals and as respected, valued.
Okay, I'd like to thank Barry Seidel, whose website is queensprobate.com. As you've seen, he has a lot of information for the general public and marketing ideas for lawyers out there. And Barry will have you back again. And we have a separate podcast available about his book. I'd like to thank everyone for listening to Law You Should Know. If you missed any part of this show or want to tell someone else about it, please go to nccradio.org and please tune in at this same time next week for another program on Law You Should Know.